The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du Tribunal Pénal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Yeah, we are going to deal with some administrative matters first this morning, left over from our last hearing. Mr. Nice, it may be convenient if we begin with at least a discussion of what it is that needs to be resolved this morning. The matters which I have are the final selection of Croatia Rule 92 bis witnesses.
Mr. McEwen's ready to deal with that.
Good. The FOTCHA transcript witnesses.
Mr. Broom's ready to deal with that.
And are there any other matters you want to deal with?
After that, if I can just mention a couple of things, a couple of minutes literally.
Yes. We'll begin with the 92 bis witnesses. Mr. Kay, you're ready on that.
Yes, I think we can save time because the general point that we've seen run throughout all of these subsequent witnesses has been the issue of the JNA, as mentioned within those statements.
Yes.
Which has been the point that the amici have made on behalf of the accused over the issue of cross-examination.
Yes. Well, it may be convenient to deal with it with you going first, really. Then, if you're in a position to.
A little bit inconvenient, as I've got to find those statements.
With Mr. McKeon, who's probably ready to go. The numbers which I had were 1055, 1086, 1089, 1136, 1162, 1175, 1185, 1191, 1215, 1238.
Yes, Your Honor. I've tried to put these into smaller groups of like witnesses for the convenience of the court. First of all, I would note that these are all crime-based witnesses, and so to that extent would be cumulative of the testimony of Gruic and Strinovic. The first group, I think, starts with 1086, also includes 1136 and 1191. These I would call witnesses to ethnic cleansing. Witness 1086 deals with the ethnic cleansing of the Erdoot area. Witness number 1136 deals with the ethnic cleansing of Elak. And witness 1191 deals with the ethnic cleansing of Bapska. These witnesses are all cumulative of the testimony of Mr. Shelabai, who dealt with the ethnic cleansing of Lovas. And I would also note that there has been one 92 bis witness already admitted under 92 bis, and that will be witness C1126, dealt with the ethnic cleansing of another witness. So I would group those into one group. The next witness on the list I have would be 1238, which deals with the Lovis minefield incident. We've already heard testimony on that incident from Tomislav Shelebai, and I think the Amici at least agrees that this witness is cumulative of his testimony. The next witness I would have would be 1175. This is a witness to the Lovas Farms incident, different incident from the Lovas minefield incident. This is the person who buried some of the bodies which were found on that. We have already considered under 92 bis the testimony of C-1154, which was admitted under 92 bis for this incident, and also C-1071, which was admitted under 92 bis. Actually, the testimony under C-1071 and this particular witness deal with the very same victim. It's testimony about the same person. The next group deals with the two incidents at Dahl, paragraphs 50 and 51 of the indictment. That would be witness C-1185 and witness C-1215. For this incident, we have testimony in court already from C-25 and C-13, and then admitted under 92 bis already for these incidents are C-1187 and 1140 for paragraph 51 and 1052 for paragraph 50. Finally, the last group I have would be three witnesses, 1162, 1055, and 1089. These witnesses all deal with Archon and killings that the indictment alleges were committed by Archon's men. Witness 1162 will identify was arrested by Archon and will identify other prisoners who were held by Archon, including some of the victims named in our indictment. C-1055 will testify that after one of the victims was arrested, the very next day he was told to move into the victim's house, indicating some knowledge that the victim was not going to come back. And then finally, C-1089 deals with Klisa. He was arrested but later released and will be able to identify some of the victims. And I think that's the entire list, Your Honor.
Yes, thank you, Mr. McKinney.
Yes, we've now moved on since the original filing by the Amici Curiae, and a number of these places are now familiar. So we cannot dispute that they represent a cumulative basis of the evidence of the prosecutor. The issue that remains is that of cross-examination, which we contend should be permitted to the accused to cross-examine upon the issues that are important to his case, and within the issues that are relevant to the indictment, is the issue of the JNA, and we have already made objections in relation to that matter. Which the trial chamber has ruled upon and permitted cross-examination. And so that applies again to this batch of witnesses.
Does it apply to all of them?
It applies to, I don't actually have my sheet here with me, Your Honour, I apologise for that, but I can, off my memory, it applies to all, save 2 witnesses that didn't mention the JNA.
And I note 1089, 1162.
Right, it was 2 witnesses, was my memory.
1185. I don't know if you'd have your note to look at over the adjournment.
Yes, I can try and locate it. We moved courts, as you'll recollect, on the last Thursday, which has put me in a bit of difficulty, but it was 2 witnesses alone, from my memory, that did not mention the JNA. And I would have to say about those witnesses, again from my memory, they were very general, cumulative witnesses.
Thank you. I think. Mr. Milosevic, on that particular issue, is there anything you want to add to what's been said?
Well, you know, Mr. May, yourself, my basic objections, and I assume that you have managed to read through the statements, although I don't know the time you have at your disposal to do that, but I assume that you found yourself that all the things that those witnesses say has nothing to do with the authorities of Serbia or with myself. So I don't really understand why we have to listen to the witnesses about all the terrors of the war, the terrible things that happened during the war, but have nothing to do with Serbia. But that's up to you. That's the way you work. It's become standard practice here.
Very well. We'll move next to deal with the different issue, which is the Foča witnesses who gave evidence in other proceedings. A total of 11. Who were, first of all, cross-examined, secondly, of course, gave evidence on oath in those proceedings. So it may be that different principles apply. The trial chamber, again, will have under the rule to decide, first of all, whether to admit the transcripts, and if they are admitted, whether the witnesses should be called for cross-examination, although they had been cross-examined in the earlier proceedings. The issue, no doubt, will be as to whether there are other issues, any other issues on which they should be cross-examined. We've read the written submissions on this subject, so there's no need to repeat those. Yes, Mr. Groom, perhaps you could introduce the matter generally. It may be of assistance.
Yes, Your Honour. The 11 witnesses who the prosecution has referred to, and similarly the chamber as the FOCHO witnesses, are 11 witnesses who testified in the cases of Prosecutor v. Kunerats and Prosecutor v. Kornielats. In this case, you have ruled on 92 bis already with respect to a similar submission regarding 8 witnesses from the Dokmanovich case. I will tailor my remarks regarding these witnesses to address the criteria articulated as the basis of your consideration and decision with respect to those Dokmanovich witnesses, namely the proximity of the witness's testimony to the acts and conduct of the accused, and therefore its admissibility under 92 bis D, and secondly, whether or not these witnesses should be called for additional cross-examination by this accused. If I may begin with, Your Honor, the 2 witnesses B 1542 and B 1543. They both testified in the Kunerats case and were known in that case as FWS 75 and FWS 87, respectively. B 1542, in addition to providing general evidence about the takeover of FOCHA, described her experience of being repeatedly raped and abused over a period of 3 months. And she described her personal knowledge of similar acts against other women and girls. B 1433 tells a similar account of her captivity and repeated rape by several men over the course of 2 months. With respect to the first inquiry regarding proximity, there can be no reasonable view of the evidence that these 2 women, that it is proximate in any way to the direct acts of the accused. It is not the theory of the prosecution case that this accused was in any way directly responsible in the actual commission of these crimes or had any direct authority over those who physically perpetrated the crimes. It is our theory that although very remote from these crimes, his participation in a joint criminal enterprise as defined in the indictment facilitated and resulted in foreseeable crimes like these to occur. With respect to a consideration of whether these witnesses should be required to appear before this chamber for additional cross-examination by the accused. Before I address this question with particular respect to these 2 witnesses, I would like to make some general submissions regarding this question. The prosecution fully recognizes that the attendance and cross-examination of witnesses is one of the most important rights afforded an accused, and also ensures the legitimacy and accuracy of any decision ultimately reached by a trial chamber. That right clearly being enshrined in Article 21. But directly following Article 21 is Article 22, the importance of a trial chamber to consider the impact of proceedings on victims and witnesses that appear before it. What was not specifically dealt with in your consideration of the Dokmanovich witnesses, which I submit should be part of your consideration of these FOCHA witnesses, is the impact of requiring these witnesses to attend for additional cross-examination. It is the prosecution's submission that should the chamber balance the need to protect these witnesses against whether that protection unfairly impinges upon the rights of the accused, it will be clear that in the case of these 2 witnesses, they should not be required to appear for cross-examination. B 1542, after providing her testimony on examination in chief, was fully cross-examined by 3 different defense counsel regarding her testimony. Over 150 pages of transcript were consumed in this exercise. Similarly, B 1543 was cross-examined by 4 different defense counsels for a total of over 100 pages of transcript. The chamber has recently heard the testimony of B 1405, who suffered similar crimes, and fresh in your memories must be the difficulty and the pain which such testimony exacts upon the victims who must give it. It is our position that, nonetheless, if renewed cross-examination can reasonably be believed to assist the chamber in its determination of a significant issue in this case, the prosecution agrees such witness should be required to attend. Conversely, If no such reasonable belief exists, it is the prosecutor's position that the mandate of Article 22 requires that witnesses not be brought to attend additional cross-examination. In the case of these two witnesses and other witnesses, there is no reasonable expectation that additional cross-examination will be of any assistance to the chamber. If I might add parenthetically, as it indicated also in our written submission, B 1543 does not believe that she could endure additional cross-examination, and it is not the prosecutor's intention at this time to request a subpoena or in any way attempt to compel her to appear. We would withdraw her as a witness. What the accused's position will be with respect to these two women, I expect it will likely be, as in the past, that he will broadly oppose these procedures that have been designed to facilitate efficient proceedings while protecting his rights and interests. In the event that he does not indicate how the previous cross-examination was inadequate, or what additional areas he would seek to question the witness regarding, the prosecution submits the following. We have now been in trial for over 1 year. Clear patterns of cross-examination have emerged. Absent his willingness to state with particularity what areas of questions he seeks to put to these two witnesses, I submit the Chamber's analysis should include those areas of examination he regularly and consistently engages in.
Let us consider the submission. You say that although there's no specific reference in the rule, nonetheless, a chamber in deciding whether a witness should be called for further cross-examination should take into account the likely effect upon a witness who has suffered traumatic events, as these witnesses have. Anyone who's read that transcript will see. On the other hand, you concede that it would be right for a chamber to consider cross-examination if there was some issue, some significant issue, which wasn't addressed in the earlier cross-examinations.
Yes, Your Honor.
Is that the point?
Do not place them on a par, the rights of the victim on a par with the right of the accused to face his accuser, but simply a matter to be considered. And if there is no reasonable expectation that further cross-examination will shed new light on a new issue or on an issue not adequately covered, that the chamber would be entitled to not require the witness to attend for additional cross-examination.
Is the modern trend to take account of the impact on witnesses of being made to appear in court and retell their events, is it not?
Yes, Your Honor. Especially in cases of sexual assault and of such extended and prolonged sexual assault as in these two cases.
Yes, thank you.
Your Honor, I was beginning to say, and I was going to use as an example, the chamber, I think, is entitled to look back at the year history of this trial and to evaluate the types of cross-examination that the accused has engaged in when evaluating whether witnesses being brought here and subjected to similar cross-examination, whether that will be of assistance to the chamber. And I would use as one example, the accused routinely explores inconsistencies between witnesses in court testimony and prior statements. The chamber, if the chamber examines, in the case of both 1542 and B 1543, that this was done with facility and adequately in the previous trial by a number of different defense attorneys. there is no reasonable belief at present that the accused will be in a position to more fully exploit the differences that exist between the prior statement and the in-court testimony of those witnesses.
It may be said that point can be made in relation to all the, virtually all the witnesses that their previous statements were put to them. Not just these two, but the other witnesses too. I think I'm right in saying.
That would be our position, Your Honor. When I come to the other witnesses, it would be the same position.
And one can get some idea of the extent of the cross-examination, maybe not the detail, of course, because it's a very rough and ready test by the pages which were taken up with cross-examination. And I notice in the case of the last witness you mentioned, 1543, was it cross-examined? I have it for 102 pages, as against 67 for direct or examination in chief.
If it is of assistance to the chamber, we'd be willing to point with particularity the specific references in the cross-examination that dealt with such things, such as impeachment with prior statements.
Yes.
I'm prepared to do that today. I would prepare a chart overnight and submit it to the chamber.
We'll consider that.
Another avenue that the accused routinely explores with witnesses is parts of their testimony which appear illogical or improbable. A cursory examination of both of these cross-examinations will indicate that this also was done at length and with some facility by the different defense attorneys that question these witnesses. Finally, the accused routinely puts to witnesses information and facts that he has in his position that he believes furthers his position in the hope that the witness may be in a position to confirm those facts. It's the prosecution's submission, as the chamber regularly reminds the accused, that this is a matter more properly dealt with on the defense case in due course. The prosecution's position that a witness should not be brought back for additional cross-examination in the hope that that witness might be able to confirm a fact which the accused wishes to put before the chamber. One final matter with respect to these witnesses, Your Honor, is that the prosecution is not in possession of any additional Rule 68 material tending to impeach these witnesses that was not available to the original cross-examiners. Prosecution submits that if the chamber engages in this analysis, it is clear that in the case of B-1542 and B-1543, that they should not be required to attend cross-examination absent the accused or the amici putting forth some articulable basis that additional cross-examination could be reasonably believed to yield some new evidence or be of some assistance in the chamber's determination of a significant issue in this trial. In the absence of that, it's the prosecution's contention that the testimony should be admitted without cross-examination. As a measure of additional caution with respect to protecting the rights of the accused, the prosecution would not oppose a later application by the amici or the accused later in the trial, asking the court to reconsider this matter if it should appear towards a later point in the trial that some important issue was raised by these witnesses, and it would appear at that stage that additional cross-examination could shed light on that additional issue. The prosecution would not oppose the chamber reopening its consideration of this matter. I apologize for having taken so long with these first two witnesses. I will deal with the remaining 9 in a far more expeditious manner. The next 4 witnesses I would like to deal with are B-1015, B-1533, B-1618, and B-1120. Some of those witnesses were protected in the Focha trials, so I will refer to all of them by their assigned witness pseudonyms. In that case, they were respectively FSW 104, FSW 15, FSW 33, and FSW 111. The subject of the testimony of all these witnesses concerns the circumstances surrounding the takeover of FOCHA, as well as the conditions in the KP Dome. It is the prosecution's position that none of their testimony is sufficiently proximate to the acts and conduct of the accused as to make it inadmissible under 92 bis D. With respect to the question of cross-examination, I submit the following. The prosecution filed this motion before any of the Chamber's recent 92 bis decisions. What has emerged from the Chamber's rulings as the law of this case is that witnesses that offer evidence regarding the J&A touch upon an important issue raised by the accused and therefore should appear for cross-examination. Prosecution concedes that if the Chamber is inclined to follow this analysis, then these witnesses do speak to the participation of the J&A or the use of its facilities and would be appropriately called for limited purpose of cross-examination on that issue. With respect to cross-examination on other issues, it is the prosecution's submission that such should not be allowed. All four witnesses were subjected to extensive cross-examination on inconsistencies between their in-court testimony and their prior statements. All were cross-examined regarding those portions of their testimony the defense deemed improbable. Case 1618 was cross-examined by each of the counsel of the three accused. With respect to B 1536, the prosecution's position is similar. The witness does talk about paramilitaries from Serbia taking part in the attack on Foča, including Sešel's men and Arkan's Tiger. Again, the prosecution concedes that if the Chamber is to apply its same analysis that it did with respect to its March decision and the J&A, then the presence of paramilitary forces from Serbia may raise sufficiently similar issues that similarly limited cross-examination would seem appropriate. It is the prosecution's position that such renewed cross-examination should be strictly limited to this issue. And this witness was cross-examined by 4 different defense counsel in 2 trials. The final group of witnesses I would ask to deal with are B 1121, B 1537, B 1538, and B 1540. Respectively, they were known in the Foča trials as FSW 111, FSW 109, FWS 69, and FWS 54. This last group of witnesses address in general terms the outbreak of the conflict in Foča and describe with particularity the conditions of the KP Dome detention facility. There is no reasonable view of their evidence that such evidence is proximate to the conduct of the accused. It is clearly within the ambit of 92 bis D. With respect to the issue of cross-examination, all of these witnesses were subjected to thorough and extensive cross-examination. Attempts were made to impeach some of them through questions regarding their participation in the SDA political party. One witness was questioned about a previous psychiatric illness that affected that witness's memory, and other important matters for a trier of fact to be aware of in evaluating their testimony. It is the prosecution's submission that none of these witnesses directly implicate an important issue raised by the accused in this trial, and as such should not be required to attend for additional cross-examination by the accused. I would note parenthetically that in the case of B 1537, the prosecution has been unable to locate this witness in recent months, and the prosecution would at this stage seek leave to amend our application for admission of his testimony to be considered under 92 bis C instead of D. Of course, we will continue to look for him and advise the Chamber and the parties of any change in circumstance.
If you're going to put an application under 92 bis C, you'll have to put some evidence, or at least a statement or something of the sort in front of us, so we've got something to consider.
Yes, Your Honor. I will
If you want to do that, of course do.
I'll prepare a submission regarding the efforts made to contact this witness.
Okay.
In conclusion, Your Honor, it's the prosecution's position that the considerations of Rule 22 are entirely appropriate for consideration when the Chamber considers Rule 92 bis issue of cross-examination. Attendance and questioning in this court impacts all witnesses over a spectrum of mere convenience to hardship to actual trauma in some cases. We submit that if the Chamber duly considers this factor, there will be, and are in this case, those occasions in which there is no reasonable expectation that additional cross-examination will yield new significant information, and that no significant impingement of the rights of the accused can said to have been occurred by not requiring such witnesses to attend for a second cross-examination by the accused. To summarize our position, in the case of B-1542, B-1543, B-1121, B-1537, 1538, and 1540, it is our request that their testimony be admitted into this trial without the opportunity for the accused to ask them further questions, and that doing so is not a violation of his right to cross-examine or the general right to a fair trial. We further acknowledge that if the Chamber is to employ similar analysis to its ruling of the 27th of March 2003, that would require B-1015, 1120, 1533, 1618, and 1536 to attend for limited cross-examination. The prosecution, however, submits that such cross-examination should be strictly limited to the issue raised by the accused, namely the presence.
You referred earlier to Rule 22.
Sorry,
It's confusing. No doubt you meant Article 22.
my apologies, Your Honor. Article 22 of the statute.
Concerned with the rights of victims, of course.
Yes, and the due consideration of the rights and the cost to the victims of participating in trials before this tribunal. So with respect to those witnesses, although the prosecution acknowledges that it may be appropriate to call them for a limited issue, it is the prosecution's position that the cross-examination should be strictly limited, and would request that any decision with respect to those witnesses by this chamber include the limitations of the cross-examination to those issues.
Just one moment. Mr. Groom, you offered to produce a table overnight of cross-examination matters such as inconsistencies. We think that would be helpful if you would do that.
Or the two that I would propose would be the use of prior inconsistent statements and questions about the improbability of the testimony. Are there any other areas that the chamber would be of assistance to identify and locate?
No, I think those are the main areas. Thank you. Mr. Kay.
Yes, Your Honours. The accused has asserted on many occasions during the course of his trial his desire to question witnesses at every opportunity. This is a matter that we are dealing with now that lies within the discretion of the trial chamber, and I ask the court to bear in mind the way that the accused has presented his case and the statements that he has made as to his need to have publicly heard the evidence against him. And we submit that that is an important consideration within any trial when you are dealing with the concept of fairness to an accused. As has already been said, the accused has a right to a fair and public trial under Article 21, Sub-Article 2 of the statute for this tribunal. In the context of his trial, these 11 witnesses would not have been heard in public. Under that same Article 21, the accused has a right to be tried in his presence and to defend himself in person. Cross-examination and the questioning in direct examination of those witnesses would not have been in his presence. He would not have been able to observe the demeanor, other personal characteristics of those witnesses, and for him, the relevance of that testimony cannot be assessed for him adequately as having been within previous proceedings for other defendants facing other charges and in a completely different context to his trial. Under that same Article 21, the accused has a right to examine or have examined those witnesses on his behalf that come forward to give testimony against him. Those are the principles which we derive from the statute, which seek to provide a fair trial for an accused. Having stated those principles, it is important now to stress the reasons. The reasons why we have this public hearing, that we give an opportunity to the accused to present his case and to question witnesses and to hear personally himself what is said in the context of his trial against him. The reason why that which has been said in other trials would be inadequate for him is because previous questions would not have been in the context of his case. Previous questioners in cross-examination would not have been questioning on instructions from him, and the importance of cross-examination by other questioners always depends upon the context of that particular individual who at that time is in court and on trial. It may serve the interests in other cases of those cross-examining not to pursue interests or lines of questioning that would be of relevance to this accused, i.e., it is a self-serving process entirely. And those questioning in the previous proceedings would have been serving the interests solely of those accused on trial and not the interests of Mr. Milosevic. They are not mutual interests.
This seemed to be saying that there are no circumstances under which this particular rule could ever be applied. And therefore, really what you're saying is that we should ignore it. Because these general observations could apply to any trial.
They are rules of a rule of discretion that we submit should be used sparingly. They should not be used wholesale because they may diminish the public nature of a trial. They may diminish in that way to highlight the interests of a particular accused, and by that I mean this accused, and it is worthy of note that the rule itself was not a founding rule of this tribunal. It is something that came in later. At the time of the creation of this tribunal, it was not envisaged, I would submit, that this would be the way that proceedings would be conducted.
It wasn't envisaged, no doubt, that the trials would take as long and that there would be as much evidence. But that may be a totally different point. I mean, the fact that the founders didn't foresee these problems, I don't think is a strong point, I must say.
Why I mentioned it is that the founders were probably working very closely with the principles in mind from the statute. And it's easy to envisage situations where the principles of the statute that gives birth to the tribunal in the first place may become obscured for reasons of expediency and thereby deprive an accused of that important right which underwrites the whole process, of the fair trial.
That depends on a view that all the trials should be oral. And no doubt that was partly in the minds of the founders who gave a primacy to oral evidence. And that's what's been changed. All evidence now is treated equally. Now, I accept that, of course, this is a particular point dealing with evidence in other cases. But one has to take into account the size of the cases and the amount of evidence which is nowadays put before the tribunal. And what is required is to find an expeditious but fair way of admitting it. And that's why evidence in written form is now more freely admitted.
In a way, judging by the number of pages as to whether a job has been done or not, I would submit to the tribunal, can be a very unreliable way of assessing whether evidence has been properly challenged. Page numbers are no guide. It's quality rather than quantity, which may be a far more important way of determining how well a job has been done. We do make this point that witness B1015 at the start of cross-examination by defense counsel refused to cooperate, not answer questions, and was antagonistic. This led, perhaps, but it's a fact on the record, to the defense counsel putting obviously inaccurate facts in cross-examination and being criticized by a trial judge for it. And this highlights the problem in using testimony from other trials where the interests of the parties are not mutual, that the people performing their functions within the trial process are different, that case strategies may be entirely different, each trial strategy for each accused has to be considered as an entirely self-serving process. And I don't mean that in a derogatory fashion, but it is a fact in the way that they have to contest the proceedings. I take the observation by the trial chamber that the points I am raising are critical of this particular rule, but we stress here that this is a rule that should be used sparingly and not in a wholesale application. At the end,
it seems to me, Mr. Key, that what you're saying is that this is a rule which, if not applied very, very carefully, can be ultra-vires, this statute, in terms of the right to a public hearing and the right of the accused to examine evidence that has been given against him.
well, exactly so, Your Honour. Our submission is that this has forced the principles in a direction too far as those principles were the embodiment and the embedding of this tribunal.
Mr. Kay, let's be specific. Could you make further observation as to those two witnesses, rape victims, 1542 and 1543? What would be your position?
My position is very clear. In relation to any crimes, they should be treated with due equality. And if you start constructing a process that permits certain types of crime to be more easily proved against an accused than another type of crime, again, you are moving away from the founding principles of the tribunal, which addresses victims generally and in full equality, without distinguishing between one class and another. As yet, there has been no medical evidence of any harm that the judges should consider to determine an appropriateness in revising the usual procedures for the giving of evidence.
Are you saying that this is not a matter that we should take into account? And secondly, are you really saying that we need medical evidence to consider the possible traumatic effect of a rape victim having to come back and give evidence of a series of rapes? Surely no court needs evidence of that sort. And the final point is this. It's not a question of a separate category here. It's merely a question of whether a witness, having given what must have been traumatic evidence, or must have been traumatic for them, should be forced to come back to be further cross-examined. And whatever you say about the quality of the cross-examination, certainly the quantity is relevant when considering the length of time they must have already spent in the witness stand. Are you saying we should not take these matters into account when we consider whether we should order cross-examination?
I am sympathetic to any victim who suffered any crime, and that includes those victims of sexual crimes. And it is easy to comprehend the trauma that such victims may later experience in a courtroom. But the issue we have here is that an accused is on trial, whose liberty is at stake, and for him, the manner and delivery of evidence may be important. it has to be noted, certainly in those parts of the trial to date where we have heard such evidence, that the accused has been sympathetic and has stated no desire or wish to compound unpleasantness on the witness. So I don't want this issue to be seen as whether it's the amici curiae, Mr. Kay in particular, forcing this issue onto those victims of rape. It's not the point that I am trying to deal with. I am still wrestling with the underlying problem of testimony that has been given elsewhere in different circumstances against a different accused who has different interests, a different lawyer, and a different context for his trial. So there is no desire from this part to use this as an exercise of unpleasantness or harm to a victim. And we consider those articles within the statute as being very important, which consider the rights of the victims. But the issue here does remain the public nature of the trial, which this accused has put forward as being a very important issue in relation to not only his trial, but those watching it who may be potential witnesses, of whom he has frequently made the point he has no fear or no need to disguise the case against him in any way. One can consider it in a different way against a different accused who is not so prominent, does not feature so highly in the scheme of things, and issues such as this, if he wasn't mentioned in relation to the evidence, carry no importance. Having appeared in another trial myself, I can readily say that you let things go by because it makes no difference to your indictment, your client at that time. And the issues you are following are for a particular accused to meet the particular case against him. But in relation to this accused and his pronouncements and strategy, one can readily see that his perception of the trial and what he requires to do is very different for his own interests. If I could just turn now to the exhibits, the witness statements. It seems in that trial, for no good reason that I could see of reading the transcripts, that the witness statements went in as a matter of course in direct examination upon the witness being produced by the prosecutor.
Which trial was that?
The Foccia trial, I have terrible difficulty. Kuneratz and Knoilach, pardon. I apologize to him for my poor expression. I haven't got to that part of the course.
Well, you were saying both of them?
Yes.
And both of them, the statements went in?
Yes. It was a matter of routine. And in that way, exhibited material goes onto the record, burnt onto the record, should I say, if it's to be reused, with many aspects within those statements which are not challenged or dealt with in direct or cross-examination. That's a very different state of affairs from the position where a witness produces a map, a photograph, a plan as part of his testimony, and one could see why exhibiting such material makes sense to the transcript as a whole. But if witness statements go in like that, we can see a backdoor route for the admission of statement evidence without any proper hearing upon the contents. And as we know, that there are many inaccuracies. How they come about is not for me to say. It's just the fact that there are inaccuracies that needs to be mentioned because they affect the reliability. And if the reliability of evidence is affected, the quality of the trial diminishes. So the second strand of our submission is the issue that there be cross-examination by the accused in any event. If the trial chamber does not accede to our argument on the matter, but permits the transcript testimony on behalf of the prosecutor, our fallback position on his behalf, or what we would say is an argument open, a second strand, is that there be cross-examination. I don't know if I can assist any further.
No, thank you, Mr. McKay. Although, just one final point, I suppose we will have to look, if we were minded to admit any of the transcripts, we would have to look at the witness statements to see whether they were admissible or not. It would be open to us to exclude the witness statements.
Yes, it becomes a tricky exercise in my submission going down that route if it's just when the witness stands up, here's the statement, any objections, the presiding judge said, defense say no, and it just goes in like that, or almost like a tool of the process rather than evidence within the process, if I can make that distinction, if that makes sense.
Thank you. Mr. Milosevic, on this particular point of these transcripts.
Well, precisely on that particular point and separate issue, Mr. May, just like in all the other aspects, things here are being put topsy-turvy, upside down. The question is not whether the cross-examination has been conducted or not. It's a reversal of thesis. The question is how it was conducted and done, and what one wished to prove in each individual case. Mention is made here of a proposal according to which the facts should be accepted, facts which have been adjudicated in front of this illegal court of yours. And neither you, although you are an illegal tribunal, did not adjudicate facts, but persons, people. You judged upon people. So it was not facts that were adjudicated, and that the proposal is they be brought to your knowledge formally, but what we're dealing with are facts that refer to whether or not something took place, where, under what conditions and circumstances, and whether a person perpetrated a crime or act of any kind. That was the subject of your deliberations. In the cases which you now wish to put into one box, into one trial, which in itself is cumulative, if I can put it that way, and which represents a completely novel practice in general in trials of any kind or adjudication and judgment of any kind, which is not surprising as this is an illegal tribunal. So from your aspects, precisely from your own aspects, as you consider yourselves to be a court, you have adjudicated and judged persons and not facts. And you have judged them on the basis of facts, which in those proceedings, the legal proceedings conducted against those persons, were considered to be adjudicated, which means that adjudicated facts can only be those which refer to whether a certain person did commit a crime of some kind, where, when, against whom, under what circumstances and conditions, or any other facts cannot be considered to have been adjudicated. Mr. May, you mentioned a moment ago economics of time, expediency, and that principle does indeed exist. I do not challenge that. I do not challenge its existence. But I assume that you're not going to allow yourself to challenge the fact that when we're talking about legal courts and legal trials, this must not be at the detriment of justice. You usually tend to look at the clock, and you're interested in the time, the passage of time mostly. A legal court of law must be interested in justice, that justice being done, as opposed to the principle of expediency and economy in itself. So take a look now at what you have here before you, and putting it mildly, they are dubious facts, and that dubious facts can be considered to be adjudicated, which curtails the right for me, myself, to be able to state my views on those facts. Or by applying the means and resources I have at my disposal, or though you're trying to tie my hands as much as possible in that respect, I wish to put into question and to prove and show before the public that they have not been properly ascertained and adjudicated, that they are the result of insufficient knowledge in certain subject matters and areas, that they have been construed, for example. And even, I would go as far as to say, that their assertion emerged from a compromise of the accused and their defenses with the opposite side over there, bargaining with that side over there that calls itself the prosecution. And that is why that opposite side and this practice seems to be a sort of malignant body and acts in that way in a legal system which is being created and legal thought that is being created, because the eyes of the public see how many compromises are being struck here and bargains that are being struck with different people who are accused here, who are told to own up to certain crimes for them to receive shorter prison terms.
We are well away from the point on which you must address us. The issue is not that of the adjudicated facts, and your hands are not tied, as you know, as far as the evidence is concerned. Providing it's relevant, you can call relevant evidence. But the matter that we are having to consider now, and on which we have invited you to address us, is the issue of the transcripts which were admitted in the two cases which have been mentioned. And the issue that we are having to determine, there are 11 of them, is whether we should admit them in this particular case, with or without cross-examination. Now that's the issue that you've got to address.
Well, that's the issue I'm talking about, and I believe that I'm taking up less time than the opposite side and the amicus. I don't suppose you're going to challenge, Mr. May, are you, and gentlemen generally, one and all, that there is a complete difference of interests of persons who were judged here and the transcript of which you wish to introduce, because it was not in their interests to deal in any depth with certain issues. And as we are talking here about the general culprit of as Serbia is a general culprit on all the territories of Yugoslavia, there seems to be quite a different principle and approach here in order to establish the truth. When culpability is concerned, what I'm doing for one goal, to establish the truth and the place and role of my own people in the historical events which came to pass and which you are trying to represent in the way you are here, to determine culpability. So it is quite logical to me that in the individual cases, people had no interest in delving into any kind of historical and various other circumstances. And I wish to repeat once again, I have already said that the indictment is false and that I will break down all its allegations, and I will be able to do that if you do not curtail my right and time to be able to put that into effect. Now, whether something is essential or not essential, you must allow me to assess that. And everything is essential. Everything is of substance, because everything that took place on the territory of the former Yugoslavia, you link to Serbia, its institutions, and to myself personally. So you cannot say that you can exclude something because it is not relevant. Everything is relevant because everything is linked together, and you link it together. Even the rapes. Any drunken fool can carry out rapes in London or your own Jamaica, Mr. Robinson, or anywhere else. And I'm sure you're not going to bring the head of state to court because a criminal perpetrated a crime or raped somebody. However, everything is in play here. Everything comes into play, and you have presented all kinds of accusations here for things that neither Serbia nor I have anything to do with, and for which it is the people who committed the crime against Yugoslavia are to be held accountable and responsible.
Just let me understand you. So in relation to the rapes, you might not so much want to question the fact of the rape as you might wish to question who committed it. Do I understand you correctly? You might not wish to question the fact of the rape, that there was a rape, that these women were raped, but you might want to address the issue as to who committed the rapes.
A možda ću osporiti i činjenicu.
Well, I might even question the facts if my information tells me that a witness statement and testimony is false, Mr. Robinson, because here there have been a large number of false witnesses. You saw here somebody who said that he was a close associate of mine. That's what he claimed, and I've never set eyes on him in his life before. So, Mr. Robinson, you have introduced into evidence as an exhibit a photograph of a shirt with 3 holes in all of it, which Miljazin Tachi, a witness, brought in here, who says he was shot with a heavy machine gun from a distance of 3 meters and that he wasn't wounded because God saved him. God just didn't save his shirt. So you accept quite unbelievable things here in this court. I have received here quite a lengthy document here which says it is a proposal on the part of the prosecution for note to be taken of adjudicated facts. This is quite nonsensical because facts were not adjudicated or judged. It was individuals that were judged in a completely different context. And secondly, when it comes to these facts, there are such idiocies here in the historical sense, the factual sense, and any other sense, which quite simply you won't need any effort to challenge. One wouldn't need any effort to challenge. They deal with everything, all things together. Several centuries ago, the Serbs inhabited the northern and southern areas of Bosnia. That's what the other side claims there. They delve in history. They reshape and recut history. And it delves into all other different things. It says immediately after the First World War and the disintegration of the Habsburg Empire, this is what it says: a kingdom was created of the Serbs, Croats, and Slovenes through the unification of the Kingdom of Serbia with Montenegro, with Croatia, Slovenia, and Bosnia-Herzegovina. That's what it says here. Well, neither Croatia nor Bosnia-Herzegovina existed because they're part of the Habsburg Empire. So what kind of unity or unification are you talking about here? These are historical, nonsensical things. They've written nonsense here, a whole book of it, a whole book of facts we have here. And there's another thing they say here.
As the presiding judge indicated, that we are already through with the issue of adjudicated facts. Please confine yourself to the issue of transcript. And in answer to my colleague Judge Robinson's question, you said that you may challenge the fact that whether there was a rape or not. May I take that you are challenging that these 2 witnesses, 1542 and 53, were raped or not? Could you make your specific observations as to those 2 witnesses?
Mr. Kwon, I really do rate very highly your well-intentioned efforts, but I cannot give an answer to that question only when I have all the facts which are related to their testimony, which has not been available to me so far, because within the frameworks of my time constraints, I have to deal with current witnesses, the order of which, as you yourself know, undergoes change on an almost daily basis, so that this type of practice also makes it more difficult for me or anybody to become better acquainted with this. I do not wish to insult anyone here, Mr. Kwon, but I myself do not believe that anyone you or Mr. May or Mr. Robinson have managed to read through the 400,000 pages which have been disclosed so far, because I just do not see the time that you would have to do so, in addition to your sitting here and all the other obligations that you have to attend to, and of course the breaks that you are entitled to. So I don't think any human being would be able to read through that number of pages, but that is why you do consider that you're able to assess what it says there without having been fully informed about what it says in all those pages. Take a look at what they say here. With the Constitution of 1974, the Muslim population of Bosnia-Herzegovina...
We cannot allow time to go like this. The matter we are discussing here, and we're inviting your submissions, is about these FOCHA transcripts. We're not going over the history all over again. Now, is there anything more you want to say? We will consider, of course, whether to admit these transcripts and whether to allow cross-examination. Is there anything more you want to say on that issue? On that issue?
I am absolutely opposed to the fact that any kind of transcripts are introduced into evidence here, because it is completely incompatible with the contents of what that false indictment is accusing me of having committed. And they would now like to link it all up into different parcels and packages, different judgments brought under conditions which were suspect, under pressure exerted upon people, under conditions of compromise with the accused, bargain pleas and all the rest of it. And they want to put it all into one parcel, to tie it up, and then to have that represent a crime base or a basis of documents which are all suspect. So I categorically reject any possibility of that being done, and I hope that I have expounded that sufficiently clearly, and you can decide whichever way you like, because I wouldn't be surprised of any of your decisions. They would not surprise me either way, whichever way it goes.
Can I just make one correction? It was in relation to the exhibited witness statements. I must have been suffering from transcript fatigue. I was thinking of the Dokmanovic trial, where they went in as a matter of course, and I've been able to check it, and it was the wrong tribunal, of course.
Yeah. Thank you.
Sorry.
Yeah, Mr. Groom.
If I may just briefly, Your Honor, I think there were some witness statements actually accepted in this case. The prosecution would not oppose just a simple rejection. It has been the practice, a simple rejection of that as not being with the practice of this trial chamber. We certainly would not oppose that. And I think that raises...
When you do your table about cross-examination, perhaps you could indicate your view about the witness statements in each case.
Yes, Your Honor.
If there have been any which have gone in, then I think they should be excluded, unless they're in for a particular reason, it may be, to deal with inconsistencies and that sort of thing.
Yes, Your Honor. A similar issue has been raised here with respect to B1015, as well as just the general nature of 92 bis. The prosecution is equally bound by the transcript. There is no requirement in 92 bis that the chamber accept the evidence. It's simply that the evidence be presented, it's simply about presentation of evidence, that the evidence be presented by transcript as opposed to live testimony. The chamber would be certainly entitled, after reviewing the transcript of 1015, to find the witness incredible. The chamber would be entitled to review any of the exhibits tendered and say they are unreliable. Similarly with the rape, the chamber would be entitled to read that testimony of the rape victim and decide the chamber does not find it credible and give it no weight. Mr. Milosevic, if he has evidence that the witness perjured themselves, the prosecution would not oppose the witness being recalled to face that evidence, to answer to that evidence. So underlying 92 bis is simply the principle of presentation of evidence, and if the amici or the accused can articulate some area of questioning that they wish to put to this witness that seems plausible and reasonable to the chamber, chances are the prosecution would not oppose that witness being recalled, and the chamber certainly would be entitled to have that witness called. But I think 92 bis imposes puts it to the accused and puts it to the amici to say why should the chamber not accept the presentation of evidence in the form of transcript testimony. Why must the witness be recalled to give oral testimony once again?
we'll consider this and give our ruling in due course. We'll await the prosecution's submission of the document tomorrow. Yes, Mr. Nice, it's probably time for adjournment, unless there's something very briefly you could deal with.
I'm in Your Honour's hands. Has the court yet received the summary of the next witness?
Yes. Yes, we have it.
Shall I mention all administrative matters after the adjournment? I'll probably be about 3 or 4 minutes on administrative matters and a couple of minutes on the next witness, so it'll be about 5 minutes in all.
Well, shall we deal with that now? If it's 5 minutes, yes.
The first thing I wanted to say had to deal with the witness list served last week. I hope it's self-explanatory, but I know that the accused...
That hasn't found its way to us yet.
I'm sorry about that. The motion did, but not the witness list. The Chamber will recall that we were expelled from the building for technical reasons at 3 o'clock on the Friday, so it couldn't get on the Thursday, so it couldn't get in on the Thursday. I'll make my observations about the list when you've got it. It's silly to do it otherwise, and then the accused can perhaps follow the shape of the list, which is designed to be helpful. One other technical point, not technical point, procedural matter. The witness Patrick Ball, who was the expert called in the Kosovo part of the trial, comes back this week because of a corrigendum he wished to make his report. He's not under an interdiction that he shouldn't talk to the prosecution. Nevertheless, I should make it plain, my present intention is that he may be spoken to by us briefly, or probably not very at great length, so that we can understand what it is that he's wishing to lay before the Chamber, and then either to, with the Chamber's leave, lead the evidence, or alternatively just simply get him, either lead the evidence or get him to explain the evidence himself. In relation to the forthcoming witness, it may help you if you have before you not only his statement, or rather his summary, but the exhibits. For this reason, the witness, who has the benefit of protection, kept a diary. When he met the investigator, he provided the investigator with notes that were extracted from his diary. The diary is no longer available to him, but the notes extracted from the diary are, and indeed all of them bar one page, have already been provided to the accused. The witness is in a position to speak about 3 meetings. The diary entries dealt with those meetings, and the notes provided to the investigator are, broadly speaking, transcripts of those original diary entries. The notes provided have been marked in the margins in either red or blue. The red passages are passages which are, by and large, simply taken straight from the original diary entries, which were themselves broadly contemporaneous. The blue are notes of a different kind that the witness wrote in preparation for his encounter with the investigator. My proposal is that when we come to the evidence about the meetings, in particular, the 3 of them, the best course would be for the witness simply to go through his notes, which are sidelined in red, and then to be asked 1 or 2 supplementary questions. This will save time, but will also be the most accurate reflection of the evidence that this witness is able to give. But I thought it helpful to give you an advance warning of that being the course I was proposing.
Thank you. So we can have the witness immediately after the break.
Certainly. Oh, one other thing. One paragraph only does he seek to give, or 2 paragraphs in closed session. It's on the 2nd page, in private session, and I would ask for leave to call him on that basis.
Very well. We'll adjourn now 20 minutes.
All rise, veuillez vous lever.